Good morning, everyone. It's great to see you all here. My name is Skaidrīte Ābrama, and I am chairperson of Latvian Competition Council. I congratulate you to this event because it's the third European competition day in a row that we are today in Riga. And it's a really great event. Congratulations. And for now, it's my pleasure and honor to introduce for an opening speech to you our competition commissioner, Margrethe Vestager. Thank you very much that you have managed to come to Riga in your very tight schedule. Margrethe, the floor is yours.
Thank you very much. Thank you for all the effort that you put into organizing this day, for the beautiful venue, because coming together makes the difference to the day-to-day working of competition law enforcement. It's my first European Competition Day, and I hope it will be the first of many. I think that the effort that you have put in this as a presidency also shows the central nature of the single market and all the effort that we put into making it open, vibrant, competitive. All, of course, for the benefit of citizens. It's also important that competition and competition culture reaches to the other side of professionals working with enforcement on a daily basis. And therefore, I'm particularly happy that we are such a broad range of people coming together here today. Competition agencies, they of course talk together, if not on a daily basis, then almost weekly, when case teams work together on cases. But this system was only set up like 10 years ago. It's quite amazing, and it was one of the very, very positive surprises in getting into the competition community to learn that this network is so well working. Since May 2004, almost 800 decisions has been adopted, and more than 650 of those have been taken by national authorities. I think this is amazing figures, which shows the strength of the enforcement and the strength of cooperation. Together, we're stronger, we're more effective, and therefore also a better deterrent to those businesses who may consider to enter into something which they shouldn't. Of course, we apply the same rules, but applying the same rules is not the only reason why this has become a close-knit network. I think above all, there is a common recognition of the fact that we also pursue the same values, same basic ideas. And our legitimacy, our credibility, and also, of course, ultimately the impact of our work depends on independence from political influence and business interests. And that is, of course, sometimes a lonesome position, which is another good reason to come together. Because that shows that to be independent, well, that indeed we can do together in the network. And this also leads back to the quality of our investigations, the fair, balanced, impartial decisions. It means respect for procedural rights, due process. It must be ensured. This, of course, is only what can be expected in a union like the European Union, building on the rule of law. But it's in the day-to-day making that it comes true. There is one more factor that unites competition authorities within our union. And I think that is the realization that here in the aftermath of the crisis, where a lot of people have considered how to move on, how to move further, that competition policy matters even more Because obviously the question arises, maybe we should just protect the single market from outsiders, and maybe just protect the member states a little from outsiders, from the neighbors. And therefore, of course, I think it is crucial to be there on the day-to-day enforcement basis, but also in the public debate, to take some of the sayings and the sentences of the protection ghost right on. To say that if you really want to serve citizens, well, then you also protect competition. We need the power of the single market, and it is quite amazing how much that actually works. But it's also intriguing that there is still enormous potential to be tapped from the single market, from a true single market. This is very high on our Commission agenda. That be in digital single market. We launched a communication just yesterday. That be the Energy Union, where we launched the communication just a few weeks ago. When you look at the digital single market, it's a very broad strategy. It comes from copyright rules to telcos, from e-services to digital skills within our citizens. And following the strategy with more in-depth analysis to put, so to speak, flesh to the bones, will be the focus of our work and attention. And therefore, of course, it's also, for me, a good moment to reflect on the relationship between Commission's policy initiatives, such as digital single market or energy union, and the enforcement of competition law. Making markets work better is one of our prime goals, and we use competition law enforcement to do exactly that. And the Commission's credibility as an enforcer means that our work has to be based on facts, the interpretation of facts, sound economics, respect of procedure, and the fair application of the law. And those who talk of political influence and corporate pressures are way off the mark. So the enforcement of competition law can complement the Commission's policy initiatives without compromising the rigor and impartiality which will remain our hallmark. Of course, there are a number of different reasons why it's a slow uptake of e-commerce cross borders in the European Union. Because Europeans really like to do e-commerce. I'm one of them. Because it's convenient, it offers you choice, it enables you to do things that you would otherwise not be able to do. But why not cross-border? Why so little e-commerce cross-border? Well, of course, there can be very good reasons for that. That may be language barriers, consumer preferences, differences in legislation across member states. And that, of course, hampers or puts up barriers to the development of e-commerce within a true digital single market. And what we see is indication that companies active in e-commerce may restrict cross-border online trade within the European Union by deliberately creating private and, in particular, contractual barriers. And that, of course, I think we should look into. I guess most of you, like me, have experienced that when you're looking for something, you're being redirected. You may not be able to find the product that you just saw because it's not available because of your address or the details of your credit card. And this is why we have decided to do a sector inquiry into e-commerce. And we will ask information from a large number of firms and from every country in the European Union. And this, of course, will give us a much better understanding as to how these markets work. Our work in the energy sector is another priority area. And that is why we last week launched another sector inquiry. This is the first time that we used a state aid instrument. And what we will be looking at is an important aspect of electricity markets and how EU government supports them, the so-called capacity mechanisms. And why? Well, we hope that with competition policy, we can complement another major initiative of the European Commission, the Energy Union. The ultimate goal of the Energy Union is building energy markets in Europe that are integrated, interconnected, resilient, secure. Europe is a huge importer of energy. Number of countries being dependent on just one or very few suppliers. And therefore, what we're reaching for is something which will benefit both citizens, businesses, and the environment. The energy markets today, they are so not integrated. And that's our goal, to make that happen. If gas and electricity flowed freely around the European Union, energy would be cheaper, it would be more secure, and it would be more sustainable. I see three main problems as to why this is not happening yet. One is obviously the lack of infrastructure, physical infrastructure. And this will take investment. That's a very good reason for the European Investment Plan. Another thing is that EU governments coordinate relatively poorly, at least not well enough. And finally, there may be the problem of illegal business practices that keep markets apart. And here, competition law enforcement can address it. And we have already done so in a number of situations. For example, we sent our concerns, what we call statement of objections, to the Bulgarian incumbent Besh on 2 occasions, in 2014 and again in March of this year. The first statement of objection laid out our concern that the company may be abusing its dominant position by imposing territorial restrictions on the resale of electricity. The second statement of objection was about concerns that the company may prevent its competitors from gaining access to its gas infrastructure. A more recent example is a statement of objection that we sent to Gazprom in April. Our concern there are that some of its business practices may amount to a misuse of dominant position in breach of EU antitrust rules. Gazprom may have pursued an overall strategy to petition Central and Eastern European gas markets by reducing its customers' ability to resell gas cross-border in 8 member countries. And this may have enabled Gazprom to charge unfairly high prices to 5 of those countries. We also believe at this stage that Gazprom has made gas supplies conditional on obtaining unrelated commitments from wholesaling concerning gas transport infrastructure in 2 countries. I think Riga is a very good place to mention this, because you must be very well aware of the level of Gazprom's market share in Latvia. It's a high market share. The Commission takes the preliminary view that Gazprom is dominant in the market for the upstream supply of gas to wholesale in Latvia, and our investigation covers Latvia in 2 aspects of the case. One is the territorial restriction imposed by Gazprom, and which might have prevented wholesalers from reselling gas they have purchased from Gazprom. And the other aspect is the unfair prices Gazprom may have charged its customers. Inevitably, when we send out these statements of objection, the press gets full of speculations about political and strategic implications. And of course I understand that. But my role and the role of the Commission is to enforce the competition rules, regardless of the nationality of the company, regardless of the ownership of the company. Those who breach EU law and rules should expect us to act, no matter their background. This much for our antitrust investigations. We also use state aid tools to ensure fair competition in energy markets. What we base it on is our guidelines for environmental protection and energy. They were adopted last April. And for the first time, these guidelines include a section on capacity mechanism. Capacity mechanism refers to the subsidies and other support measures that national governments give to their utilities to make sure that there's enough electricity supply to meet the demand in the long run. A number of member states, as we speak, see a risk of insufficient investment over the coming years. And if investment will not take place, well, then we have a risk of blackouts. That's a very sad thing when the duck is in the oven on Christmas Eve. We definitely do not want this to happen because secure energy supply, well, it is a day-to-day utility for every citizen in the European Union. This is not an abstraction. This is not for lawyers and economists and far away. This is for everyday people in their household. And therefore, of course, it's obvious that member states worry and will take initiative to make sure that demand can actually be met. It's a completely legitimate concern. What, of course, we would like to make sure is that they do not only take into account capacity located within their own borders, because there may be perfectly suitable supply just on the other side of the national border. And sometimes they may also forget that blackouts can be managed by managed demand, that they may make agreement with huge users to say that if there is a risk of a blackout, well, then we pull out in order for others to make sure that they can have the supply they need. If they embark on those solutions, well, we risk inefficient solutions, but of course, we also undermine the entire idea of moving forward for a true energy union. Moreover, some capacity mechanisms only support specific technologies and companies rather than adopting a much more neutral way of finding out what to do. And this is why, of course, in our guidelines, it specifies how to make capacity mechanisms work to preserve competition and cross-border trade. What we need and what we want is good and systematic information on capacity mechanisms before deciding on next steps. And it's the first time that the Commission is using a sector inquiry in state aid. It's a new tool. But it's not a new thing to look into this. DG Competition already conducted antitrust inquiries into energy market between 2005 and 2007, and the insights and the knowledge learned from that went into the preparations of the third energy package. That was adopted in 2009. In contrast, the inquiry that we now have offset last week will address public authorities and stakeholders in member states where capacity mechanisms are either in force or planned. We want to find out how do they influence the market and how are they made. Above all, we will learn. And we're planning to publish the interim report by the end of this year, and then, of course, to ask people to comment on it. Final report to be published next summer. This, hopefully, will enable us to learn new things about how the markets work, how it can be made to work better, and therefore also to give knowledge to the building up of the energy union. To sum up, competition policy is doing a lot to help the European economy come back on track. These initiatives, well, they're part and parcel of the overall strategy of the Commission to leverage the untapped growth potential of the single market. Sometimes these words can seem remote and abstract, but growth potential can be boiled down to new jobs for young people. People who may feel restrained, may feel that they're not able to pursue their dreams of providing for themselves, of raising a family, of doing what they want to do and what the European Union should make a framework for. And that's, of course, a daily motivation that when we do this thing, when we make markets work, that is when we create the possibility for creating more jobs. And there are still so many young people who needs that. That is why the teamwork is crucial. That is why it is so important for every European agency to be independent, not to be pushed or influenced by politics or by businesses in order to be able to do our job. I think it is so important for us all to learn from each other, to get new input, but first of all, to cherish a network where authorities are truly independent, well-funded and effective to serve our citizens. Thank you.
Thank you very much, Margrethe, for valuable insights presented. Unfortunately, the Commissioner has to leave for another important meeting, and we wish you a very safe flight. Thank you very much. Okay. As you know, Latvian Competition Council is supervised by the Ministry of Economics. And the Ministry of Economics is also in charge of competition policy in Latvia. Therefore, it's my great honor to invite for an opening speech our Minister of Economics, Ms. Reizniece-Ozola, of this very important day and conference. Thank you. Please.
Good morning, dear ladies and gentlemen, dear friends and competitors as well. It gives also to me a great pleasure to welcome all of you to the European Competition Day, which has been organized here within the framework of the Latvian Presidency. Walt Disney, the famous American motion picture producer and creator of the Disneyland, once has spoken some very meaningful words. He has said, "I have been up against tough competition all of my life, and I wouldn't know how to get along without it." And dear friends, I would like us to bear in mind these words said by Walt Disney as we discuss today's main topic, an effective competition policy. This policy has a significant role in addressing and achieving the main priorities of the Latvian presidency, which are competitive Europe, digital Europe, and engaged Europe. All of this is closely intertwined because competition policy protects and strengthens the single market, be it the energy market, as broadly explained by Commissioner, or other areas. It ensures a level playing field for businesses, and it supports the innovation as well. Despite the fact that the economic recovery from the recent financial crisis is continuing in Europe, the overall uncertainty surrounding the economic outlook is still in place. And here I wish to highlight that this is a crucial moment where we should use any opportunity that enhances economic growth, including the possibilities presented by a highly competitive environment. In this context, I would like to talk about three concepts that are essential to the provision of fair competition in all economic sectors, and these are perspective, trust, and cooperation. Why perspective, dear friends? Let me mention one example. A recently published study from the Mobile Operators Association, GSMA Intelligence, shows that Latvia has the lowest cost for a mobile call minute in the whole Europe. And this is a fine example of well-functioning competition. In a relatively small market as we are, we have 3 strong mobile operators that have found ways to work better, to be more efficient, and to be also innovative. Our stakeholders, society, businesses, politicians, will always ask for such results, be it lower prices, better quality, or you name it. And there is nothing wrong to ask for these benefits, as this is what competition can and actually should provide. However, as policy makers, we always have to remember this perspective. Shifting, for example, from an expensive monopoly situation to an effective competition in the telecommunications market takes time, and difficulties start when, under the constant demand for instant results, the sense of perspective has been lost, because it's quite easy, even tempting, I would say, to get lost in the Bermuda Triangle of fear, good intentions, and short-term thinking, fear of real competition, and the good intention to help specific companies. In most cases, those are the local companies that we would like to protect, to help, together with a lack of will or ability to understand long-term consequences, leads to less competitive markets. And therefore, a great part of our work is the art of putting things into perspective, evaluating not only short-term gains, but being able to look ahead. The second core concept I would like to discuss, and I already mentioned at the beginning, is trust. It has many levels and dimensions, and all have a great impact on the economy. As simple as it is, the economy is not simply about numbers. It is also fundamentally about people, and from this point of view, it becomes easier to understand the importance of trust. Here I'd like to touch upon government's trust in private sector. The tendency of public bodies to start business activities is often accompanied by explanations such as the private sector cannot provide sufficient quality or quantity, or that it is easier and quicker to do something in-house, avoiding the need to organize the public procurements. But what if the effort is switched to encouraging competition instead of trying to substitute it for businesses run by administrative bodies? Because what we can lose by not trusting in businesses, by taking over or closing markets to competition, is something much more valuable than just one ruined business opportunity. And here again, I speak of trust. If a state loses the trust of people that it is a safe and reliable place to do business, to fulfill dreams and ambitions, we would be in a great trouble. In order to ensure this high level of trust among private businesses in Latvia, the Cabinet of Ministers supported the concept of principles for the engagement of public persons in business activities, and substantial progress has been achieved in this context. And recently, the Parliament has adopted amendments in the second reading to the State Administration Structure Law that is going to make the things better here in Latvia. As lawmakers and law enforcers, we must also earn society's trust, that there will be a level playing field and effective protection against competition law infringements. And therefore, the competition law is currently being amended to provide better possibilities for damage actions, to enable the Competition Council to better prioritize the investigations, and other changes are also envisaged. This is all being done because without adapting and growing together in accordance with the reality around us, we could not effectively ask for society's trust. The last concept I mentioned was cooperation. In times when international politics become more pressing and the European Union has to deal with countries that do not obligatory share the same values, the role and importance of internal cooperation is of high importance. Although there are countries in the EU that are different in size, historical backgrounds and traditions, we all are aware that we are a share of the single market, and if business has no borders, why should regulation have one? As things stand at the moment, however, domestic regulations can and do divide the single market, and they cannot be removed easily. Thus, part of an effective cure to regulatory framework and fragmentation in a single market is close and efficient cooperation between the competition authorities. And it is our mindset and willingness to work together that has already stepped across the borders and has given real and tangible results. For example, from the colleagues from other countries have agreed to help the Latvian competition authority and vice versa, truly working together to fight competition infringements regardless of where they are located. I also know that different countries carry out our common sector inquiries, thus matching their research to a geographical market. And here we have a very successful example of the Nordic competition authorities who have carried out valuable inquiries in various markets and are currently examining the waste management sector. Ladies and gentlemen, friends, today's conference addresses all the core concepts I have mentioned in various combinations. In every panel, we will be asked how much should government intervene and how should it be done, if at all. And I do hope that today's discussions will either give the answers or at least help to pose more precise questions that will move an effective competition policy and competitive markets forward. And I'd like to conclude with three questions for you, for the panelists, for the audience. First, are we successful enough in putting things into perspective? At this moment, my answer would be not yet, but no one has promised that this would be easy. And I believe that the key to success is finding clear and strong arguments to show the benefits of long-term thinking to all our stakeholders. Second question is our trust in private business sufficient? And at the moment, I do see a lack of trust. Public bodies sometimes tend to believe that making profit is in contradiction to honest work, providing good quality and fair prices, but practice shows otherwise. Striving for profit is the best motivation, usually also for a better service provision, and thus at this point we have a choice to learn from our mistakes or not. And the third question is, do we have enough cooperation between competition authorities? I have already mentioned some examples, so the answer would most probably be yes and no. The European Competition Network has proved itself a very effective EU competition law enforcement tool. However, there is still room for closer convergence in respect of procedures, as well as national competition authorities' rights to achieve a level playing field in all member states. Dear friends, we have to stay committed and sustain sufficient political will to strengthen the competition policy. And I'm especially grateful to our keynote speakers today. And I do believe there will be a really positive outcome from this conference. Good luck, and thank you very much for this day.
I thank our Minister for opening speech. Thank you very much. And now, please kindly allow me to say some welcoming words at the opening of this conference to Minister Reizniece-Ozola, ladies and gentlemen, dear guests, experts, colleagues, friends. It's my pleasure to speak today on this stage on interaction of economy and competition culture. First of all, I would like to stress that for Latvia, this conference is very important. It's the first time we have honored to host it. However, competition law and competition policy in Latvia has already 23-year history. Exactly half of this time it has been developed, shaped within the family of European Union. And this time for us as competition enforcers, as competition authority, has been intensive, dynamic, and as a result, I have to say very certainly that very fruitful and rewarding. The time since early 90s when our country switched from planned economy to market economy and to competition culture almost overnight has been an unbelievable, intense journey to people, businesses, and also to competition enforcers themselves. During this period, step by step, learning from the best and also from our own success and failures has developed our understanding of further needs and ways to effectively implement competition policy in Latvia. Our approach and vision is that efficient competition policy is possible only if there is an efficient and active competition authority with a long-term perspective on competition enforcement. An authority that is independent, impartial, and professional. An authority that knows the markets and is able to promote competition rules and oppose competition distortions even when they are supported by governments or politicians. Only then it's possible to provide mutual interaction between real economy and competition culture so that it works for the benefit of consumers, and which is our main aim and goal. And therefore, the Competition Council of Latvia has always been at the forefront of competition advocacy and competition assessment, despite the lack of efficient mechanisms to counter, for example, state or municipal anti-competitive distortions or lack of sufficient resources. The Latvian Competition Council nowadays concentrates on really high-impact enforcement that involves swift and decisive actions against the most severe antitrust infringements in first-line cartels. In recent years, this has been accompanied with the preventive work, which has started to play an increasingly significant role in our day-to-day work. That means that today we are complementing strong enforcement with promoting, shaping the competition culture among businesses and in the society as a whole. That involves also advocating relentlessly against competition distortions created by decisions or actions of state or municipal institutions. In general, I am convinced that competition regime in Latvia works well. Speaking about further developments, I'd like to underline that the Competition Council acknowledges safeguarding and promoting competition is a continuing process in order to be able to face new challenges and to find the most appropriate legal or economic solutions. I believe that today's conference, Broadening Borders for more effective competition protection, will contribute to further development of competition processes within Latvia and the all European Union as well. Therefore, today we propose to your attention the three following topics: ensuring level playing field between public and private-owned businesses, updating perspective for tackling today's cartels, drawing a line between constructive and destructive buying power of large retailers. I know that these topics are important not only for Latvia, but in many countries within the European Union and beyond. To continue about interaction of economy and competition culture in Latvia, I would like to bring to your attention the following. Latvia has small open economy and none of the sectors is excluded from application of competition rules. 3 out of top 10 largest enterprises in Latvia still are state-owned. Some of the state-owned companies do maintain dominant position in the markets even after they have been liberalized. Like in many other EU member states, municipalities are very eager to implement the idea that doing by themselves means establishing their own companies instead of creating an investment-promoting environment for businesses. In Latvia, both state and municipal enterprises are treated just as other market players, and they are subject to the competition law. By now, the Latvian Competition Council has addressed nearly all largest state-owned enterprises, either through enforcement, sector inquiries, or through competition advocacy. There have been cases on abuse of dominant position or soft law enforcement in various significant regulated public utility sectors against powerful market players in the railway industry, airport industry, Riga Freeport Authority, telecommunication operators, the only Latvian natural gas supplier, up until this year the only electricity supplier, largest postal service provider, etc. However, as our Minister of Economics, Ms. Reizniece-Ozola mentioned, not always mistakes are learned from. For example, it's already the 3rd time when the competition authority has to intervene against an abuse of dominant position by the Riga Freeport Authority. Namely, Riga Freeport Authority, after purchasing its own tugboats, didn't hesitate to use its administrative resources and various unusual methods to exclude any competition and block the activity of private tugboat services in the Freeport of Riga. Freeport Authority has been fined already twice for the analog infringement, and this is the 3rd time when the Competition Authority has to intervene. At this point in the investigation, the Competition Council has sent its statement of objections to the Riga Freeport Authority and given an additional period of time to the Riga Freeport to formulate its response. I hope that sooner or later the Riga Freeport market will be open to private tugboat businesses on fair and non-discriminatory conditions, promoting investment-friendly attitude towards ports clients and partners across the world. So the question remains open: what can and should be done when public bodies establish their own companies and enter fully competitive markets? And mostly this is not the case when economic activities are commenced in strategically important markets or new markets that cannot develop otherwise. We know that market entry of a public body involves great risks. There are many examples when competitive advantages deriving from administrative resources or from in-house service provider position or status have distorted level playing field, pushing private enterprises out of markets. And when one is clear, in such conditions, there is no motivation to innovate, to invest, strive for efficiency. And sadly, I do not speak about only several such cases. Thus, I hope one of today's discussion panels will shed light on possible solutions. Further speaking of interactions between economy and competition culture, I would like to bring to your attention that sectors providing basic goods in Latvia or services are fragmented, mostly small and medium-sized businesses. There is a strong public procurement sector in Latvia. In 2014, funding for public procurements constituted 11% of the GDP. And here in public procurements, unfortunately, far too often prevails a desire to win by any means except fair competition. 60 to 70% of all competition law infringements established in Latvia in last years have been bid rigging cases. The number of applications on alleged bid rigging has been so overwhelming that in smaller, less significant cases, we do not initiate even a case. Instead, we issue a warning. This year, we have already warned 11 undertakings. But there are also very severe infringements that raise a question. How could society and market participants tolerate such behavior without noticing and without intervention? In 2014, the Competition Council established a systematic cartel between 7 distributors of Volkswagen cars, including importer. These enterprises had maintained a cartel scheme in procurements for more than 5 years, and only thanks to leniency application, this infringement finally was disclosed and terminated. Here, I would like to mention that this was only the second leniency case in Latvia since its introduction of leniency program in 2004. Unlike in many other EU member states, and regardless of our tireless efforts, leniency has been used very little in Latvia. The understanding about the criminal nature of cartels in Latvia is still insufficient. That is why we have to look for new ways of getting signals on cartels, and therefore Latvian Competition Council is actively seeking cooperation with public institutions to prevent conditions that encourage procurement cartels and also to receive information on the possible infringements. Thus today, I believe it will be inspiring to hear the views of academics and practitioners on how to find and fight cartels. And to conclude about the interaction of economy and competition culture, our third panel discussion will focus on the relationship among retailers, suppliers, and consumers. I know that the topic is in a way controversial. Does the concentration of modern retail bargaining power of retailers against suppliers in the long term work in the favor of consumers to satisfy their needs, to receive a diverse, high quality and price-friendly offer? Latvia is a typical country with a highly concentrated retail sector of several powerful supermarket chains and a number of small and medium-sized suppliers, not being happy with the conditions set by the retailers who have this bargaining power. Like in many other countries, there is no exemption. Suppliers are afraid to stand for their rights as a full-fledged business partners. 7 out of top 10 largest Latvian enterprises that constitute 28% of national GDP in 2013 are wholesalers and retailers. It means that wholesale and retail sector is very strong in Latvia. 2 largest supermarket chains also belong to this group of powerful companies. In 2008, a specific article on prohibition to abuse market power in retail trade was introduced in the Latvian competition law. And since that time, the Competition Council has carried out 6 case investigations, mostly initiated ex officio. 3 of these cases have led to establishing an infringement. Also, suppliers admit that relations with retailers have become more transparent and a number of complex issues have been solved. Still, we hear complaints, mostly anonymous, that the regulation is insufficient. The new draft law on unfair retail practice, now elaborated at the Parliament, will broaden the scope of the respective regulation to address not only large but all retailers. However, the implementation will still be assigned to the Competition Council. Thus, the question of the third panel of our conference, how to approach and assess relationship between retailers and suppliers, how effective can regulation be, how far should the legislation intervene, and the competition authorities intervene. I am very happy and grateful that the conference panels will be moderated by such high-level experts as Dr. Anders Balzov, Rector of Stockholm School of Economics in Riga, Alexander Italianer, General Director of DG Competition, Dr. Gunnar Strautmanis, former President, now Vice President of Latvia's Chamber of Trade and Commerce. And it's our honor to have as panelists the leading scholars in the field of competition law. Professor Alison Jones, I do not see, Professor Eleanor Fox, Professor William Kovacic, Professor Michael Kramer, researcher Victoria Doskalo from Tilburg Law and Economics Center, Chairman of OECD Competition Law and Policy Committee, Dr. Frederick Geny, Head of the Food Task Force DG Competition, Philippe Shaw, and Head of the Lithuanian Competition Council, Šarūnas Keserauskas, Head of the Swedish Competition Authority, Dan Sjöblom, Board Member of the Netherlands Authority for Consumers and Markets, Anita Vekter, President of the Office of Competition Consumer Protection in Poland, Adam Jasse. Welcome to all. I know that in the audience we have representatives of the national competition authorities from all EU member states, as well as from Norway, Ukraine, Bosnia and Herzegovina. We are pleased to see the judges, civil servants, lawyers, representatives from NGOs, representatives from companies, media. Welcome all to this conference. And very, very welcome to all participants who are here. Therefore, I hope that ahead of us there is an active discussion. I do encourage you to take the chance to participate, to ask the questions, because speakers of this level in the one room in Latvia is a very specific occasion. And now, before we start the panel discussion, we will have a coffee break, as I believe the early morning asks for additional energy. And representatives of national competition authorities are now welcome to make a family photo in the lobby. We will meet here at 10:10. It means after 35 or 45 minutes. I will wish you all an exciting conference. Thank you.